All right. Welcome, everyone, to today's webinar. We've got Arielle Tucker here from Connected Financial Planning. She's the founder and lead cross-border planner there. And then we've also got Sasha Young from Areia Global Legal Advisors. She's a tax and estate planning attorney. Just a few admin things before we start. Today's webinar is worth one CFP continuing education credit. After the presentation, you just navigate back to the dashboard within FPA, and then you complete the course evaluation to get the continuing education credit. And if you have any questions throughout the presentation, feel free to message in the chat. We might answer at the end or during it, depending on how things progress. But all right, Arielle, you want to take it away?
Okay, thank you so much. Okay, so like Dan said, my name is Arielle Tucker, and I'm a certified financial planner and enrolled agent specializing in cross-border tax and financial planning. And I'm so excited to be here along with Sasha to unpack a topic that is increasingly relevant. I think it's always been very important, but it's something that keeps coming up with the families that I'm working with right now. So before we dive in today, let me just offer a quick disclaimer. This presentation is for informational and educational purposes only. It does not constitute legal or tax advice, so please be sure to consult with qualified professionals for specific individual circumstances. And because this is being recorded, please be sure that if there's any questions in the chat, that you don't put any client-specific information in that chat. So here's what we're aiming to cover today. So understanding global estate and inheritance tax frameworks, how different countries approach taxation of wealth transfers, identify how treaties and exemptions can help cross-border clients avoid double taxation, and navigate common compliance challenges and understand what financial planners need to be aware of when advising international clients. By the end, we're hopeful that you'll walk away with a clearer sense of where your role fits in and when to bring in outside legal or tax experts for deeper collaboration. So while I'm not an estate or tax attorney, I thought this would really be the perfect opportunity to share some of the key issues I've been navigating alongside my clients. So many of those clients are in their 40s and 50s, and they're preparing to receive US-based inheritances, or they're married to non-US persons. For those of you who don't know me, I've spent 15 years immersed in the world of cross-border tax and financial planning, both personally and professionally. I first moved to Switzerland back in 2011 and have been building and living a life abroad ever since. I'm the founder of Connected Financial Planning, a fee-only financial planning firm that works exclusively with globally mobile individuals and families. Our focus includes clients with ties to Switzerland, Germany, and Portugal. I write for Bloomberg Tax on a quarterly basis, offering insights on US tax and financial considerations for Americans living abroad. In fact, the inspiration for today's talk came from a recent article I wrote on estate planning for international families, a topic I've been beginning to dig into deeply, especially as many of my clients living or moving to Germany come face to face with unexpected inheritance tax obligations. I invite you to connect with me or follow Connected Financial Planning on LinkedIn, Facebook, or Instagram, where I regularly share resources on tax planning, financial strategy, and navigating the expat life. When Dan asked me to speak, I knew I wanted to bring in a partner who could offer additional perspective and support you and your clients. So I'm especially grateful to be joined by Sasha. Sasha, I'll let you introduce yourself.
It's a hard act to follow. I'm very excited to be here with you guys today and presenting with Arielle on this. My name is Sasha Young. I'm the managing partner at Areia Global, and we handle tax and estate planning for American expats in Portugal. Yeah, most of my clients are either sort of approaching retirement, or they're coming here with young families. And so estate planning is sort of top of mind for our client base. Personally, I have been sort of walking in this space as well for a while. I am originally from the Caribbean. Then I went to the States when I was studying, and lived all over Latin America and in Europe my whole life until I settled in Portugal 5 years ago. So working with other expats and people who are navigating what it means to cross borders and have ties to all sorts of different countries and jurisdictions is close to my heart. And I'm glad to be able to talk about that with everybody today.
Thank you so much. I'm still like so happy you're doing this with me because it's just, I think when you can bring other people in, and especially in the world of cross-border, this is such an important lesson to remember. It's very collaborative. I don't know everything, and I'm happy to tell you that I don't know everything. And so it's great when I meet other professionals like Sasha and like Dan to just kind of become resources to connect and make sure we can do the best for our clients. So to kick things off, let's just start by grounding ourselves in one of the most important distinctions in global estate planning, the difference between estate tax and inheritance tax. So because I am assuming that most of us are US financial planners, I'm sure you're very familiar with the idea of an estate tax, which is the tax on the estate itself. Um, Assessed before the assets are distributed to heirs. It's paid by the estate, not by the beneficiaries. In contrast, many European countries apply an inheritance tax, which is levied on the individual receiving the assets. This often means the tax burden depends on the relationship to the deceased and where they reside at the time of the inheritance. It's important to note that residency of the inheritor of the asset is usually the trigger for inheritance tax, and citizenship is not a requirement. This distinction has major planning implications for international families with heirs and assets spread across multiple jurisdictions. Another layer in Europe is the concept of forced heirship, which we see in countries like France, Germany, Switzerland, and Spain. These laws can limit how much of your estate you can freely pass on and mandate that certain portions go to specific heirs, and usually that's children or spouses. So again, understanding these kind of foundational differences is the key to identifying tax exposure and uncovering planning opportunities for your clients with cross-border ties. And for the clients who are residents but not citizens, those nuances become even more critical. Do you want anything to add to that, Sasha?
I do.
Okay.
Yeah.
Dive in.
Yeah, I think when we talk about estate planning, we're talking about a couple of different things, right? We're talking about the succession of assets themselves and, to some extent, like retitling this asset from belonging to the decedent to belonging to their heirs or beneficiaries. We're talking about the taxes that can be triggered by those transfers, taxes on the estate, which is the decedent's estate, right? That's their estate tax, taxes on the inheritance that the inheritor inherits. And sometimes we're talking about transfer taxes and documentary stamp tax and things like that. We're also talking though about incapacity planning and guardianship, and there's lots of different layers to a complete estate plan that vary hugely based on different jurisdictions and are very impacted by the US, the sort of state where people have ties, and the country where they have residence. But in this transfer of assets from the decedent to their heirs, when we're talking about common law and civil law countries and regimes and like basis of the law, the tax is only a part of it. So a person dies with a bunch of assets. Those assets go to their beneficiaries, and in a common law country, they go through probate first. And it's the decedent's estate that goes through probate. All of their debts are paid, creditors are identified, taxes are paid out of the decedent's estate, and then the distribution is made to the beneficiaries. In civil law countries, those assets vest directly in the heirs, in fact, through life, and that's what the sort of forced heirship idea is based on. Those assets kind of belong to the dogs. Kind of belong to the beneficiaries, and they have an interest, a vested interest in those assets during the life of the person, and so all of their debts, their creditors, there's not that probate opportunity, that buffer to kind of settle the estate in that way, and so those responsibilities also fall on the beneficiaries. And so when you've got kind of a mixed match of jurisdictions and you're looking at how all of this works together for one person's estate, you're talking about, you know, the individual who maybe is American and they're living somewhere else, but you're also talking about their beneficiaries who may have stateside parents who are going to pass away and leave assets. And the beneficiaries are in a civil law country where they're going to have responsibilities to settle that estate, where they are going to have inheritance tax when the estate tax has already been paid on the US side. And so it really gets sort of complex to reconcile all of those things. But I guess I just wanted to add that the tax is one piece of it, but we're talking about a lot of different pieces, and we're kind of talking about the different layers of family of a particular family as well.
Yeah, and I have to laugh a little bit because I go back to when Dan was like, you know, write down, prepare what this presentation is going to be about. And I think we gave him like a course, like a course level amount of information that we could potentially cover. And at the end of the day, this is just an hour. And so we're trying to, I think, just give some information because I know personally there are so many things that I am just starting to become aware of. And so it's like the idea of forced airship. I had never heard of that when I first left the US. Like that concept is so different. In the US, I mean, you can just really just pick whoever you want to leave your estate to, and you have a lot of say and control over that. That's not always true in Europe, especially if you want to become a citizen in a country in Europe, right? That kind of changes the dynamics of things. And then also this idea of inheritance tax. I get a lot of calls from individuals, especially in Germany, where they say, I've just inherited, you know, a couple million dollars from my parents, and I'm ready to get, I'm ready to get started. I'm ready to get investing. And we start to talk about inheritance tax, and they're like, no, that doesn't apply. And I'm like, are you a resident in Germany? Well, and I'm not a citizen. Okay, it doesn't matter. And so oftentimes we're having like hard conversations. So for current clients, we're having these conversations proactively, but our people who are coming to me with kind of what we call like the new money, that they've just inherited the money, it's that can be a hard conversation to say, okay, now we have to take a step back and make sure things are done correctly if you plan on staying a resident in Germany. So we'll walk through and give the, you know, best framework that we can. But I think what you started to touch on really highlights there's so much more to know here. And it's also why I work with partners who are experts, who aren't just generalists. You're not a generalist, Sasha. You're really truly an expert and you're in the regions that you cover. And I think that's a really important thing to highlight as well. It's really hard to know everything about every country. And even in some of the countries that we're talking about today, the rules change every year or every couple of years, and we'll see major reform. If you have to stay on everything that's happening in the US and then everything that's happening abroad in every country, I don't believe that you can possibly do it. So look for those specialists. So, and we are talking a lot about tax, and really we're talking about tax because tax is always my passion too. That's like my fallback on things. I also feel like to be a really good cross-border financial planner, you have to kind of just fully embrace tax and understand it a little bit more deeply than if you were only just to serve US-based clients. Um, so going back into understanding like the framework of the US estate and gift tax framework, let's just take a quick look at how the US system works when it comes to estate and gift taxation, because this is really oftentimes the foundation of our clients' planning decisions, especially decisions that they made maybe prior to moving abroad, right? That they kind of have the basic understanding. I mean, I think even in the US, if you only live in the US, estate planning can be complex, especially in some particular states. But a lot of clients will have proactively done their estate planning in the US and now they live abroad. And so it's important to just again go back that domicile and residence are really irrelevant for US citizen when it comes to estate and gift tax framework, because US citizens are subject to income tax on their worldwide income. Of course, there are lots of provisions to reduce or eliminate double taxation. But this is just for people in this room who maybe are not aware that US citizens are subject to worldwide reporting and taxation. gift tax on their worldwide transfers and estate tax on their worldwide assets, regardless of where they live or how long they've been abroad. So even if someone has been outside of the US for decades, unless they have formally expatriated, which we are seeing a massive, massive increase on expatriation requests and planning this year, they're still subject to those rules. So as of 2025, the federal estate tax exemption is currently $13.99 million per individual, meaning that most estates won't trigger estate tax, at least under the current law. And I think, I don't know if Sasha, if you know this off the top of your head, I think I saw a statistic that less than 2% of US estates are subject to estate tax. So really, I think that, again, this is just to set the framework and just to say, this is part of the reason why we're not always planning from the US perspective. Oftentimes we're doing a lot of the planning from the foreign country perspective because the thresholds are so much lower. And as I think probably everyone here understands, we aren't currently expecting the exemption to well, the current provision of $13.99 million is supposed to sunset in 2026. But under the current administration, we would expect that high estate tax exemption is going to continue to remain in place. But if we do an administrative change in a couple of years, it could drop significantly, potentially to half of its current amount. So again, I think it's just to highlight that planning still needs to be a consideration for long term, especially with those high net worth clients. There is an unlimited marital deduction, but that only applies when the surviving spouse is a US citizen. So if the spouse is not a US citizen, the estate must consider potentially the use of like a qualified domestic trust to preserve that deduction. Sasha, do you have any insight to add there? I know that trusts get tricky because not all countries are familiar with trust, and I'm curious, with your clients, do you use qualified domestic trusts?
Yeah, QDOTs, we love an abbreviation, right?
Yeah, sorry.
QDOTs are a planning tool. I was like, I didn't even realize that that's what it stood for. I haven't seen that word written out in a while, but yeah, they're definitely one of the tools in the toolbox. But what a QDOT does, to not get too into the weeds on it, is it delays the payment of the estate tax to the death of the second spouse. And so when you have a non-US citizen spouse, their exemption amount is $60,000 flat, not adjusted for inflation. It's just a set amount. It's been that amount for a long time, and there's no sort of expectation that that will change. And so what a QDOT does is delay any tax payment until the death of that spouse. It's not really a way to get around the tax. It's just a delay of the tax. And there are a lot of ways to plan to reduce the actual tax burden. It depends, of course, on like when the cross-border space, what countries and jurisdictions we're talking about. But QDOTs, we're thinking of those things for taxable estates. So if a non-US citizen spouse has a green card, or that's where domicile does come into play. If they're domiciled in the US, they'll have the full exemption amount. And that can be passed. So 14 million between a couple can be passed freely without tax. But whenever we're talking about taxable estates, and really whenever we're talking about estates that are kind of north of 7 million, we want to start talking about advanced planning, because even though the exemption is really high right now, October, if we haven't seen any movement, then we're wanting to make sure, and perhaps even like August, we're wanting to make sure that people are moving assets into trust to preserve that high exemption amount. And we don't know where the exemption amount has been 3.5 million, to 14 million. So it does have a big fluctuation potential. So anything north of 7, I would say you want to start thinking about something more advanced than an RLT. And whenever you have a non-US citizen spouse, whether they're in the US or overseas, for sure, then we want to start thinking about advanced planning.
Yeah. Yep. Going to the gift tax side of things. So for clients, we always remind our clients that they can gift up to $19,000 per recipient. So that's indexed for inflation. So it goes up every year, every couple of years. That was for 2025. So that does not reduce their lifetime exemption, going back to that $13.9 million. And then gifts above that threshold are definitely possible, and sometimes from a planning perspective work really well. And those are just reported on Form 709, even if no tax is actually due. Um, And I think I want to go back to what we see a lot of times working with globally mobile families is the importance of Form 3520. Um, because oftentimes a US person will receive a large gift or inheritance from a non-US individual, and then you have that reporting obligation. And that would be if you receive more than 100,000 in a calendar year. So it's a reporting requirement. It's not necessarily a tax, but there are potentially penalties for failing to file. So it's critical that clients are just aware of it. And if you hear your clients like, oh, I received this gift from my grandmother who's German, that's great. It doesn't necessarily mean they owe any tax. They're bringing this money into the US tax system, but just make sure they have that filing requirement out of the way. And I think you were just at a conference and we talked briefly, like, have there been any major updates on Form 3520 or Form 709 that I'm missing?
Um, there have been, I'm trying to think in terms of like time and complexity, what's worthwhile to cover. I will say one big trigger that people don't often think about is when you have a US citizen spouse and a non-US citizen spouse and gifting between them, or one spouse buying an asset that the other can enjoy of, and that also being a taxable gift, or if it's not taxable, reportable. And the threshold amounts between spouses, where one is not a U.S. citizen, is different. And so, whenever there's a mixed nationality couple, you've got to think about gifts between them, which we don't think about on the U.S. citizen side, where you have sort of the unlimited marital deduction between spouses.
Yeah, that's so important. I think we have a slide that covers that a little bit more too. So I'm looking forward to getting to that. So again, we're just starting with the framework of US considerations. And so now we're still gonna talk a little bit more about US federal estate tax, and then we're gonna start to bring in some international elements that we can talk about. And again, I think this just goes to the importance of when you do cross-border, you have to understand the domestic rules and then of course how they interact with the local rules and kind of like the global concepts. Because again, the rules that we have in the US don't always match up or align at all with what we think should happen abroad. So I think this slide, I think we covered most of this in the previous slide. Is there anything else to add? We'll go into, I have a good slide on states. The next slide is on states, but if there's anything else you want to add here, let me know before we move on.
I would just add that the exemption is unified between gift and estate, right? So any gift tax filings during life will reduce the amount of estate exemption available. So, anytime that you have something that's above the threshold that needs to be reported, it does have an impact on the ultimate estate tax.
Yeah, and I think that's why we have that reporting requirement, because then that's what kind of tracks
Yeah.
that the gifting.
Exactly.
Perfect.
Mm-hmm.
Okay. Okay, and then I just love this slide. If you are here and you also geek out on tax, I highly recommend checking out the Tax Foundation. They have some amazing graphics and resources. I just thought that this is a great visual of which states have estate and or inheritance tax. And what is interesting to me is I didn't even realize that there were some states in the US that actually had inheritance tax until I started looking into this for clients, because I start to ask clients now very proactively, okay, where you're based in Germany, you're based in Switzerland, or wherever you're based in Europe, but where is your family based? Where does your family have assets? Because that's a super important understanding like where is the money going to be coming from and how is that going to like transfer over potentially. Just quick on the state tax level, it's not nearly as common. Obviously, most states don't have a estate or inheritance tax. You can see from this graphic, 12 states and DC impose a separate estate tax. So that's in addition to the federal estate tax, but at much lower levels. So again, like the Tax Foundation is a great resource if you are like, oh, how much is that? And I mean, it's sometimes it's like $1 million. That's not very much if you are talking about families with um, doing advanced planning. 6 states actually have inheritance tax. And then, of course, we have Maryland, which is a state I never want to live in, which apparently has both inheritance and estate tax. So, and if you look back on these graphics, this is the graphic for 2024, but you'll see that the concept of states having a state tax, having an inheritance tax it's been phasing out. There were more states 15 years ago than today. So this definitely has been phasing out. So even if your client is below that federal exemption, which again is crazy high, you really have to consider state specific rules could still apply to their situation, especially if they own real estate in any of these jurisdictions. Anything to add on the state side?
There are workarounds. I mean, I think that it's why we favor trust-based planning so much because, as you mentioned, like I live in a certain place, my family's from somewhere else, we have assets in different places. It's really easy to end up with sort of a multiple probate um, case and to sort of run a probate risk in a state where you're like, I don't live there. But if you don't retitle assets into trust, then that's kind of the situation that you end up in. So probate in Florida is 12 to 18 months and costs 3 to 7% of the estate value, the total estate value. So
Whoa.
it's a long, painful process. And then families always fight the whole way through. So like, it's something to be avoided. Yeah.
Do you have a favorite state for trusts? I'm putting you on the
Depends on the
spot because we didn't talk
client.
about this.
Yeah. Yeah. I mean, Florida is a great option. There's no state estate tax in Florida, of course. And then in the cross-border scenario, we just like to maintain flexibility. We like to be able to decant trusts, to change trusts, to move trusts to different states, to move things around once they become irrevocable when the person passes away. And so Florida is a good one. When you're looking at, high net worth and ultra high net worth, you're looking at South Dakota, Wyoming, Tennessee is like the, hot new cowboy on the scene. A state that's looking to attract a lot of that trust work. Arizona. So there are a few, sort of random states. Nevada is a great one. But yeah, we're looking at a handful.
Okay. So
Forum
the
shopping.
theme is those states have no tax either. So that's
right. Yeah.
Yeah. Okay, great. We already talked a bit about the filing obligations, but I see this again so often that we decided to do another slide on it because I see clients trip up on this. The U.S. reporting requirements tied to estate and gift transfers. So this is just to kind of make sure you're aware of what we need to do. So Form 3520 and Form 709, I think we covered those already. But I think additionally, it's important to note that when a client inherits an interest in a U.S. trust, they may actually receive a separate Schedule K-1 reporting any income from that trust. And that income would then be reported on their individual return, even if the trust is foreign. And I think that's really important to just kind of be aware of as a planner, because let's say someone passed away, everything goes into a trust, and your client is used to always filing their tax return in like April or June. And a lot of times we won't get those K-1s until the fall. And so I think it's just really important to, when you're doing a tax return check or review for your client, just to be like, oh, did you get that K-1? Make sure they get that before they file their tax return and get the appropriate extensions in place. The other thing to mention here, the inherited retirement accounts, they have their own set of rules, as you know, as a planner. So beneficiaries may owe income tax on those distributions, even if there is no estate tax due. So coordinating the timing and minimum withdrawals is very important from a planning perspective. And it's also worth noting that clients with financial accounts or foreign trusts may have additional reporting obligations like a 3520A, FBARs, 8938s. So these often go hand in hand with any international estate structures. So really important just to know, takeaway here is bottom line, when dealing with global families, tax compliance is a lot more than just strategy. It's also knowing about when and what to report and avoid unnecessary penalties. Anything else to add there? Because I know like you're a tax lawyer.
No, I mean that's very comprehensive, and I think those are forms that people are not always thinking about outside of the cross-border context, especially the 3520 and 3520A. So if you got gifts from foreign persons, gifts from foreign trusts, if you have a U.S. trust and someone moves overseas, the trustees overseas or something like that, and it becomes treated as a foreign trust, it's very easy to trigger those 3520 and 3520A filing requirements.
Okay. And then I think this is a really interesting graphic. So this is basically looking at what countries in Europe have estate inheritance and gift taxes. And we're focusing more on Europe because I mean that's what I know. I don't know anything. I really don't know anything to do with this, South America or Asia. So this is kind of why I keep tying Europe in. This is my expertise is Europe. And I think it's just really interesting and also useful to remember how long these concepts of estate inheritance tax have been with us. So inheritance tax actually dates back to the Roman Empire, which collected 5% of all inherited property to fund soldiers' pensions. So today it's very widespread in Europe. So 24 out of 35 European countries covered in this map current levy estate inheritance or gift taxes. But I think it's also just a good reminder here to take a step back. So estate taxes are levied on the estate itself and paid before the distribution. Inheritance taxes are levied on the recipient of the assets and based on the value they receive. And then gift taxes are applied when assets are transferred while the donor is still alive. So just something to be kind of aware of. Different countries that you are working with may have one or all of these concepts that you have to navigate for your clients. And they're all going to have very different thresholds and considerations than the US.
Yeah,
Okay.
the only thing I would add to
Oh,
that, and sorry if I can just jump in really
yeah.
quick, is that I would just call attention again to the fact that you've got the individual and they're moving around, but if their parents are living in different places, so if you're living in Europe and you've got an inheritance tax to be worried about, and your parents are living in the States and they're just thinking about their estate tax, those taxes cannot be offset. One against, you can't get a credit for those. They're different taxes. So you've got to think about all of the different levels of a family and where they each are.
Yeah, and it's so funny that you mentioned that because when I start having conversations with families where I know this is going to be an issue and we're proactively saying you have to invite your parents into these conversations. We actually have a PowerPoint presentation that I'm like, here, sit down over Christmas or whatever holiday you're going for and run your parents through just the highlights of how inheritance tax works, just so that they're aware of what is coming. And I basically see families go, well, I guess I could say three ways. One, bury my head in the sand and pretend it's not happening because it's too complex and too expensive. And I just literally don't have the time or mental energy to like think about this. Two, parents say, it's really nice that you live in Europe. We're really happy you live in Europe. That's your choice that you live in Europe. So if you don't want to be subject to inheritance tax, we would love for you to come move next door. We'd be so happy for you to come back. Thank you so much. Like, not our problem. Basically, not our problem. And it's not. And then the other that finally families go all in on this together. And they're like, okay, we want you to get the money. We do not want, name European country X here to get the money. So we're going to do whatever it takes to make sure that our planning makes sense from multiple countries and jurisdictions. So I don't know. I'm sure that's kind of maybe what you see as well with your families that you're working with.
Yeah, I'd love them to all be, the latter, but they're mostly not. Yeah, it's nobody likes to talk about death unless you're an estate planning attorney and you do all day long. So
yeah, which that's why we know them. Okay, this is you. I'm excited to hear you talk about civil law versus common law. I think you mentioned it briefly when we started. I don't know if there's anything else that you want to go into with the differences between civil and common law countries here.
Yeah, I mean, we did talk about it to some extent. So like we'll just kind of refresh that piece, right? common law countries, the US, the UK, Australia, those countries have like really wide freedom of choice in how you leave your estate. And so there is, a marital sort of piece of it where spouses usually have a right to a certain amount of estate, but that can be waived in a prenup, in a postnup. We're generally like, leave it all to the Red Cross, fine by me. You've got a lot of freedom there. In civil law countries, generally you have some kind of forced heirship regime there that says most of this estate has to go to this person's heirs at law, their spouse and their children. Maybe a third can be, left to someone outside of that, but there's a pretty narrow, section of the estate that people have freedom to do what they want with. And that's, sort of uncontroversial on its face, but you see it cause a lot of problems between spouses from different countries, because it's really important from a tax perspective that a non-US citizen spouse, especially if they're living abroad and they're a total NRA, they don't have a green card, they don't have a visa, they're not captured at all by the US tax net, that if they inherit US situs assets, you're talking about a very tricky tax situation, low exemption amounts, huge tax burdens. And if there's dual citizen children, those kids could inherit $14 million tax free. And so, with some planning, you really can avoid a huge tax bill, but you've got to navigate those forced heirship rules that are in effect where they live, and where, most of the time they are going to be subject to those rules by nature of their residence. And we're definitely talking about that in Europe, in France, and Germany, and Spain, and Portugal. And that means that you've got to have that sort of comprehensive, estate plan with a U.S. trust, ideally, perhaps a local will, and then, powers of attorney in each country, and different things to make the entire thing work together in a way that makes sense for the client and is sort of tax efficient. I think that's probably the most that I'll add there. We've got some examples of different countries and their inheritance tax, estate tax kind of regimes. But as we mentioned in the last slide, Europe, we're pretty much looking at forced heirship. There are, largely civil law countries. We're looking at inheritance taxes. In the States, we're looking at estate side taxes. And then in South America and Asia, like, we're not even getting into that piece of it right now, but you're talking about a mix of both. Especially in South America, countries that have a civil law base and then sort of this new world influence, it can get tricky very easily.
Yeah, no, I don't know if you have any, I want to spend a little bit, a moment talking about Portugal, because I mean, that's your home base, right? So I'm gonna throw some balls at you. Because I think a few years ago, Portugal actually had an inheritance tax and they got rid of it. And they've just gone to the stamp duty tax. And I'm curious, the stamp duty tax, does that also apply when I understand a stamp duty tax applies where it's real estate and bank accounts, like based in Portugal. Does that apply to non-citizens, or does that only apply to citizens in Portugal?
So it applies to Portuguese assets, and only Portuguese assets that are not passing in the direct, lineage. So it won't apply to assets that are inherited by children or parents. I think between siblings it does. So, it's really a narrow kind of exemption, but we're kind of that girl in Europe. We've got no estate tax. We've got no inheritance tax. We've got this sort of limited stamp duty. But that's very different from a place like France or Germany, where you really are, kind of weaving like a very like fine thread between these two regimes, and where trusts don't exist as a matter of local law. And all of these countries have sort of an understanding of how they will treat trusts, how they will tax trusts, and how to, make sure that people that are living there are not avoiding their forced heirship rules by just dumping everything into trust. So it's not that trusts don't exist here, so like I can just put everything in a trust and that's fine. no, you have to kind of work around the local regime, which is aware that trusts are out there, and that's a strategy that people will take. But as a matter of law, there's no Portuguese trust. There's no um, truly French trust, and so we've just got to find kind of ways to, yeah, to either use trusts, foundations, companies, to make sure that in a cross-border sense, you're not just getting caught in all of the webs. Which, if you do no planning, like that's how you're going to end up.
Yeah, and I think like I love when people call me before they've moved. Those are always my favorite calls because then we can kind of make sure things are set up correctly. And one of the things that we're having to do right now in Switzerland is work on getting um, basically a tax ruling, like that first tax year that they're filing. We're making sure we're getting tax rulings on if they have trusts or anything else going on from like an inheritance point of view. And then in Germany, again, I think it is, I know Germany really well. And so that's why I'm going to highlight it. The amount that you can inherit from a parent is 400,000 euros. Now, the dollar has weakened against the euro in the last week. So that's a little bit more than it was 6 months ago, but that's not very much. That's not very much. And it also looks over a 10-year time period. And so regular gifting becomes really important from a German planning perspective. Um,
Mhm.
so just kind of little highlights there. I think another thing I want to make sure that's really important to know is from a paying tax, uh, like citizenship is often very irrelevant. It's much more, tax exposure is really based on the residency of the deceased or of the heir, the location of the assets, the presence of a treaty that defines taxing rights. And so again, this is what makes it so complex. And again, every family that we work with has completely different circumstances. Are they living there for 3 to 5 years or are they living there permanently? Right? How healthy are their parents? Like there's a lot
Yeah.
of layered considerations before we just like, open up a budget of 20 grand to do estate planning. We're really trying to understand that situation deeply.
Yeah, and the strategy is going to depend on that
Yeah, oh
family
yeah,
because, like you
absolutely.
said, if
Yeah.
someone's only here for a couple of years, then that's very different than here forever. So yeah.
Okay, so now we're getting a little bit more into tax treaties. Right now, the U.S. has signed estate and gift tax treaties with around 14 countries. So that really includes UK, France, Germany, Switzerland, Canada, Japan. These treaties are really aimed to prevent double taxation by assigning taxing rates based on residency, domicile, or situs of the assets. But in many cases, it just kind of helps the advisor understand who has the right, especially for families with global ties. Depending on the specific treaty, your client may be able to claim a foreign tax credit for taxes paid abroad, use treaty-based exemptions or deductions not available under standard rules, or apply treaty definitions of domicile that help override local law and shift tax rates. But I think this goes back to something that you mentioned in the beginning of this presentation is yes, we have treaties in place, but sometimes we have different taxes. And that's like a really important concept, right? We have inheritance tax in Germany. We do not have inheritance tax on the US side of things. So oftentimes, and we see this with a lot of different types of taxes. Like wealth tax doesn't exist in the US, so we don't get to offset that in the same way. So it's just kind of important to understand we have different taxes, and estate tax and inheritance tax are not the same. And the treaties often don't address different types of taxes. So even though there's technically no double taxation on the same assets, if we look at Germany's much lower exemption thresholds, which I mentioned, 500,000 euros if it's to your spouse, 400,000 if it's to your coming from your parents, there's still, potentially significant tax exposure. And it's also important to just mention that I just don't believe that treaties help US citizens as much as people think that they do. I mean, I think like there's this like idea, this concept like, oh, there's a treaty in place, therefore I'm not going to be ever subject to double taxation. And I think, treaties are actually written more for non-US persons than they are for US citizens. So that's my other side comment there.
Yeah. For sure. And I think people think they do way more than they actually do. Even like, well, I could get a tax credit for that. You can get it's creditable up to the amount that would have been due in the other place. So you're paying the higher of
Mhm.
the two. In
Yep.
Europe, that's not doing anybody any favors. So yeah, the existence of a tax treaty doesn't mean like sit back, like all everything's gravy.
Yeah, and I like one example that's just kind of coming to the top of my head on that is, and maybe this is a terrible example, but like thinking about like German home ownership, right? And you can pass kind of the primary home if the children remain a resident, and then it's kind of like tax free. And that isn't always going to work in the same way as it does in the US. So when you go to sell that home, maybe it's tax free in Germany. Now in the US, you got the step up in basis, right? The when you inherited the property. But if you continue to live there for 10 more years, you might have some capital gains on that property now. So again, it's like now Germany hasn't taxed it, but the US has, and so there again, so many examples of just tax timing differences and things just not lining up like you would think or hope that they would. So it's just really important to become very aware of this stuff.
Um, let's see. Yeah. So some key planning tools, I think trusts are the big ones. When we're talking about cross-border families, as I mentioned, probate avoidance is a huge piece of it, especially when you're looking at multiple probates, multiple jurisdictions, and wherever you have probate risk. So if someone is here and their immediate family is here, they've disinherited an immediate family member, and that person lives in Arizona, like they have grounds potentially to bring claims where they live. So you've got to think about where everyone is, um, and the probate risk that exists everywhere, or you funnel things into a trust, and you kind of minimize the massive jurisdictional footprint that globally mobile families can have. So I think stateside, people like wills and they will feel like, well, I've got a small estate, or I don't have a ton of assets, or my assets are very simple, and I want them to go to my spouse and children. So a will is fine. But in a cross-border context, we really, really strongly favor trust where we have them as a planning option, which we don't always. Um, so trust-based planning is one approach. Gifting strategies is another one that can be really impactful over time, especially gifting assets, uh, non-cash assets, and so assets that are going to grow down the line. That may be a strategy to have an impact in the long term, to reduce the overall size of the estate. And then I guess I'll also make the point about offshore trusts, that people ask about all the time. It's kind of like expatriating. It's one of those things that people like, how about this? Like, this is my idea. And it's like, dun, 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 for Americans, doesn't really work. Offshore structures are great for non-Americans, and for example, Europeans who have forced airship rules that might, want to work around. They might be in a position to consider those jurisdictions, but Americans have a worldwide reporting obligation, worldwide tax obligation. And so offshore jurisdictions don't offer a huge tax savings there. The context that they're sort of most helpful in is for asset protection. And so if you have assets that you're concerned about, it might make sense to move them offshore, but that's a whole, we could do a whole presentation on just the tricks of asset protection and how dangerous that world is. So I think those are the big points to cover here. Maybe we'll also put the plug in for what you mentioned at the beginning, and that is that you really need experts on the ground. It's not sort of enough to say talk to an estate planning attorney, in that country, because if they're in Europe, there may not really be that many quote unquote estate planning attorneys. In forced airship civil law countries, things go how they go, and so there's not really a market for that. So you might be talking about a succession lawyer, you might be talking about a tax lawyer that specifically works with international people or with Americans. But you really kind of need to get a team together of advisors that are specialists when you're talking about cross-border families.
Yeah, we'll talk about that a little bit in a couple of slides. But one thing I really want to make sure I just throw out there is if you are doing trusts, you probably don't want to have your trustee be the person who's based abroad. We had that
Oh yeah.
like ever. And in no
Yeah.
case, make sure. So we've had situations where mom and dad do the trust, they do all this advanced planning, and their favorite son or daughter lives in Germany and they want them to be the trustee. No, 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 no. You don't want them to be the trustee because they've essentially just received everything. They have control of everything, right? It's a lot of control issues.
Yeah.
Because again, I think Germany didn't even recognize trusts at all until like the 90s. So these concepts are still really, really new in Europe generally, and a lot of countries are going after them a little bit more aggressively because they're just seeing them as tax avoidance structures, which
Right.
not so much like planning. So that's one thing to know. Same thing with you can control a lot with a trust. For example, we have a client who we're preparing to inherit a $3 million property in California. If that was not put into some kind of structure, they would have to potentially pay tax on that property. It's an illiquid asset. Like where is the money coming from? So just really want to highlight the really importance of getting this done, and getting those family members on board, especially if there's a sentimental property or something that you're going to have to liquidate to pay the tax on.
Yeah. And I'll just add really quickly to that,
Yeah.
life insurance. Life insurance is a huge, huge, huge planning tool in the cross-border space because we've got lower like exemption amounts in different countries. And that's cross-border life insurance is another thing. But generally speaking, for American decedents, they want US based life insurance, even if the beneficiaries are not American and even if they're not living in America. But so you want to be thinking about life insurance for sure when you're talking about cross-border planning.
Yeah, that's a good point. And I think if you can get US life insurance, you should. Everyone should have US
Yeah.
based life insurance because it's so much cheaper than it is, right? The US has this massive pool of people. You compare that, you go to these tiny European countries with declining populations, insurance is more expensive. So getting your clients to do insurance, making sure before they move, making sure that that insurance will still be valid if they move abroad, all of those types of things. Because we've also reviewed old policies that we found out, oh, you had this policy in place. They've checked, it's not enforced if they're actually outside of the outside of the US. So again, adding that to your list of things to do and think about for your cross-border clients. Um, Sasha, we're having so much fun and we only have 7 minutes left and we have a lot of slides to get through. So we've talked a little bit about some of these different scenarios already. And I think really the main considerations is the takeaway I want you to have from this slide is for scenario 1 and scenario 3, there's still US persons, right? And so, and I get this question a lot, like I'll constantly talk to they're like, I'm a Swiss US citizen living in Switzerland, and so I just want to focus on Switzerland. Cool, you're still a US person. And that's a really important thing because what you would do if you were just a Swiss person or just a German person is completely different than what you would do if you were also a US person. And it's really the US that kind of adds the complexity to this, unfortunately. So just kind of be aware of that. And then obviously, if we have a non-US person and they have US based assets, that's going to be just different planning, right? So really just, I think to segment very quickly, we have US people, that's one planning, non-US people with US real estate investments or other investments in the US, different planning. But I'm going to fly through this slide to
Yeah.
get through the rest of it in the next 6 minutes. Compliance, we already talked a little bit about, compliance from a US perspective, but it's really just important that, compliance is going to vary country by country. It's really important. Like what works in one country for your one random client that you have in Japan is going to be completely different than what your one other random client in the Netherlands has to do. So it's just really important to be like aware and understand that all those reporting requirements could change at any time. Just like how we have major US tax reform every few years, same thing here. So we're adding just a lot of complexity. So become the expert in the countries that you want to serve. and know that inside and out. You are going to add so much value to your clients, and you're not going to go crazy trying to keep up on 27 different, regulations. Um, so, reporting foreign inheritances or gifts abroad is really important in a lot of countries. Declaring trust distributions of foreign held assets is important. There's different local versions, and that could be local within the country and then also or within the canton or state, depending on how the country is set up. So just being aware of that. And then really the common theme here is many countries require beneficiaries to proactively report inheritances within a specific time frame, and that's often within a 3 to 6 months of receiving the gift and inheritance. So just be aware, because I had one client who said their planning was going to be mom and dad die. They don't want to do advanced planning. We're just going to move back to the US before Germany figures that. And I'm like, it's pretty quick how you have to report these. And again, I'm all about tax planning. I'm not about tax avoidance. So yeah. Um, Coordination is just so important in the cross-border space, communication between the advisors. So again, you're building a team here for a lot of families, estate attorneys, tax preparers, wealth managers, local legal counsel. It's just really important to understand who you're going to need. And oftentimes I find as my role as a cross-border financial planner, I'm the first person kind of educating my client about what's happening in the country that they're living in. They have not come across it. They haven't thought about it. We're having these conversations very proactively with our clients so that they're aware of like what's coming, what's going to come up. Having the proper documentation, wills, trusts, deeds, asset inventories, tax filings, it's super important. Ultimately, the best planning strategies can fall apart if the reporting isn't done correctly. So that's just really an important thing to know. And this is where I really see my role as an advisor, where we add a ton of value, making sure that things are being correctly, being another set of eyes, and being an advocate for our clients in this process. Okay, I'm going to keep going unless you have something super important that I missed.
No, let's keep going.
Okay, cool. So, I mean, I think if hopefully the takeaway here for our discussion today is cross-border estate and inheritance planning is rarely something that one advisor handles alone. It's really, again, it's really important to collaborate with the right experts to truly protect and support those globally minded clients that you want to work with. Your team really matters. So again, it's like oftentimes we're not coordinating just across countries, we're coordinating across generations, cultures, and currencies. So this stuff is just really important to understand and kind of think about in a really multifaceted way. Our clients are increasingly finding themselves, living in one country, holding assets in another, having children who are also moving abroad. So it's build your network and proactively build your network. I spend a ton of time investing and building in my network because I know that the value that brings to my clients. So very, very important to go make friends and get connected with people in this space. You don't have to do it alone. You do need the right network. So I would say, again, I think this is where there's a huge value add in just becoming an expert within a couple of countries, rather than just saying, I do all general estate, cross-border financial planning, because you need to build a team of local experts who can support you. And it's really important, and it's really why I always look to refer clients to specialists rather than generalists. And if you're struggling to like connect with other cross-border financial professionals, I would reach out to them proactively and offer to pay them for their time. There is a massive shortage of people in this space. People don't have time to just grab a coffee with you. So if you're looking to make those connections, offer to pay for their time and learn from them. Their time is very valuable. It's more important that you kind of start to establish those connections, because again, this is your job to help advocate for your client. And then I know you're probably going to have questions and we're out of time. So we're not going to be taking questions today, but feel free to reach out to Sasha if you have follow-up questions. We both offer paid consultations to support you and your clients as you navigate cross-border estate tax planning. Thank you so much.
Thanks all.
Thanks, everyone. Feel free to reach out to Sasha and Arielle if you have any questions.
Okay, great. Thank you.
And happy end of tax season.
Yeah, have a great
For
night.
some of you,
Bye.
for those in the US.